Hello and welcome to our webinar, Employment Laws of 2024. I'm Angela DLHA Ashley. I'm founder and managing attorney at DLHA Law Group. We are a full-service business law firm with an emphasis on employment law and a strong focus on superior client service. Thank you so much for joining us today and giving us your lunch hour. As I said, this webinar is Employment Laws 2024, so it's about the new employment laws and any changes, as well as some contractual updates. And the attorneys presenting today are attorneys that practice at our firm. The information that you'll hear today sounds like legal advice, but it's actually not legal advice. To provide you with legal advice, we would need to sit down with you, understand the circumstances and facts that you're facing, and then apply the law to those circumstances or facts. But today is meant to give you a broad overview of the employment laws and their changes. And if you have any specific legal questions or concerns, please do reach out to us. You can see our site there at the bottom of the screens, which is info@dlhalaw.com. And that's info@dlhalaw.com, or you can call our office and we'd be happy to talk to you. And we have a lot to go over, so I won't take long, but I'm just going to go over a couple of things. I'd like to mention that we're going to have a question and answer session at the end of the webinar. Please use the Q&A function on your screen at the bottom, not the chat box, and we'll try to address all of your questions at the end. If we don't get to one of your questions, or if you think of a question after we've concluded, please again reach out to us. We'd be happy to help you at info@dlhalaw.com. With that, I'll get started by introducing our presenters. First, you're going to hear from Lindsay Meyer. Lindsay is the senior employment attorney at DLHA Law Group. She heads our employment team in providing legal advice and representation to our business clients regarding both federal and state employment-related matters. Next, you'll hear from Deanna Maxfield. She's part of our litigation team, and she has a background in employment litigation and experience in state and federal courts and arbitrations. I will be your facilitator today, and I'll start the webinar, but first I just want to go over a couple of compliance issues that you'll want to watch for in your company. The first is your company handbook. The company handbook is like your HR Bible. It's one of the most important things you do is to make sure that it's updated and compliant each year, because it's the first place you should go. It's the first place we would go, and it's the first place your employees will go if they're facing a situation or an HR problem. So it has to be current and reliable. Next, and along with that, you want to review your workplace policies and procedures. Those can be new procedures that come up during the year, or they can be policies and procedures that are accompanying your handbook. All are perfectly fine, but you want to make sure that they're compliant and current. You also want to make sure that you're posting your updated required postings, like your California Civil Rights Department postings, OSHA, wage orders, and everything else that is required. And you want to make sure that it's visible by employees in a place where they can see it and read it easily. And last, you want to consult with trained and experienced employment lawyers. And you want to ask questions before a problem arises. We usually tell our clients, work with us as you would a CPA and talk to us before you have a problem, but when you have a question, and that way we can help you avoid any trouble or issues going forward. So again, thank you for joining. And with that, I will turn it over to Lindsay Meyer. Lindsay?
Good afternoon, everyone. Thank you very much for joining us today. We have a lot to cover, and I hope that you do find this webinar educational and applicable to your particular business. With that, I'm going to start us off by discussing non-compete and non-solicitation agreements, which many of our clients over the years have had in some form. As most of you probably know, California is one of those states that generally has not permitted non-compete agreements, but recent law has even expanded that further, making it even more difficult to have any form of a non-compete, including non-solicitation. So that's what I'm going to be covering today. Now, as we all know, California law provides that any contract that restricts someone from engaging in a lawful profession, trade, or business of any kind is void. And there's only a few exceptions. So again, that's why in general, non-competes have been found unenforceable in California. But with this recently passed legislation, Senate Bill 699, just for your reference, and Assembly Bill 1076, they have further impacts on how California employers are able to use non-solicitations and non-competes. So these laws went into effect as of January 1st of 2024, so this year, and they have amended the business and profession codes in several ways. And I'm going to highlight for you the top 4 ways that they have been impacted by the new laws. Now, first, the definition of non-compete is even broader now. Assembly Bill 1076 has now codified the California court's broad definition of what non-compete means, and it includes provisions that bar the post-employment solicitation of a firm's clients. So the statute makes clear that this section is going to be read broadly and in accordance with a recent California Supreme Court decision. The decision was Edwards v. Arthur Anderson. And in this matter, the court found that a client non-solicitation provision was invalid. So again, just to give you an idea, specifically in the Edwards case, the company Anderson, part of their employment offer was made contingent upon the employee, Mr. Edwards, signing a non-competition agreement, which prohibited him from working for or soliciting certain Anderson clients for limited periods of time following his termination. Now, while that sounds fair and reasonable to, most employers, the court ultimately held that that was not enforceable. So if your company does have provisions like that, you will want to take a hard look at them, especially in light of the recent updates and the broadening definition of what a non-compete means. Now, the status of post-employment employee non-solicitation restrictions. So let me say that again so I'm clear. Post-employment employee non-solicitation restrictions, that is a bit less clear, but these provisions are also potentially covered by the statute as well. So we know from the Edwards case that post-employment solicitation of a company's clients, that is included in what and a non-compete essentially. So that is now invalid if you have any type of restriction like that. What's unclear is if companies are still using restrictions on their employees' post-employment ability to solicit the company's employees, like, hey, do you want to come work with me? I just left. However, it does seem likely, and there have been recent cases where it looks like the court is including those type of non-solicitations as well. Just to give you an example of what a post-employment employee non-solicitation restriction would look like, you may have seen provisions that state an employee shall not, during their employment and for a period of time, maybe 1 year following the termination of such employment, directly or indirectly solicit any person who is an employee of, we'll say, the company, to leave the employment or actually interfere with the company's relationship with any person who is an employee of the company or who was an employee of the company during the period commencing 1 year prior to the termination of the employee's employment. So again, it can be very confusing, but a lot of companies have had these provisions in place to protect them. So if you do have provisions like that, they are likely unenforceable now. And there are a few exceptions. But again, if you do have those, you'll want to consult with your legal counsel to see whether or not they're still enforceable. And if not, there are other actions that will be required of employers and companies now because of these updates to the law. So secondly, and I'll get to the other requirements, but current and future agreements are covered by these updates as well. So specifically, agreements that contain these, what we're calling now impermissible covenants, restrictive covenants, are unenforceable regardless of where or when the contract was signed. That's an update with these new laws that went into effect as of the first of this year. And they're also unenforceable regardless of whether the employment was maintained outside of California. So that's very important. Now, Senate Bill 699 specifically prohibits companies from entering into a contract with an employee or prospective employee that includes a provision that is void under this chapter, meaning the non-competes, and provides that any contract that is void under this section is unenforceable regardless of where and when the contract was signed. So again, it's very important that the employers recognize it's not just for California companies with California employees. So and I'll get into who specifically is covered. But an employer that enters into a contract that is void under this updated version of the California Business and Professions Code, or who tries to enforce one of these unenforceable provisions, will be committing a civil violation. So again, be cautious, and there are monetary penalties associated with that as well. Now, there is one potential issue with this. There is a specific labor code section that permits California-based employees to agree to an application of another state's laws. So, and the updates to the Business and Professions Code is silent regarding that particular California Labor Code section. So again, that potentially could still be okay, but the broad language that's been applied because of these recent updates to the law, in particular, the application to contracts, regardless of where and when they were executed or whether the employment was maintained outside of California, it's going to cast some serious doubt on whether or not even those provisions under the labor code can still be enforced. So again, if you have any agreements that are restrictive in any way or appear to be restrictive in any way, or that you have an agreement where an employee is agreeing to submit to the laws of another state, you're going to want to have your counsel look those over just to make sure everything is still enforceable, valid, and possibly some revision may be needed. Now, probably the most burdensome issue that's come up for employers because of these updates to the law is that specifically under the AB 1076, employers and companies are required to provide written notice to employees that are subjected to any of these unlawful restrictive covenants. And also, it's not just current employees, it's provide written notice to former employees who are employed at any time after January 1st of 2022, and that signed an employment agreement containing a non-compete provision, a customer non-solicitation provision, or other similar provision. So this notice is required to be provided to current and former employees as I explained above, and it was already due to be issued as of February 14th of 2024. The notice is required to be written to the individual who entered into this now unenforceable agreement, and it needs to be delivered to that particular employee's or former employee's last known address and the email address of the employee or former employee. And there are, again, penalties associated with failure to provide these notices. And there are civil penalties of up to $2,500 may be imposed on non-compliant employers. So again, this written notice is something that was already required to go out by employers who have had employees who entered into these unenforceable restrictive covenants. And I do think that there will be some forgiveness for employers because this is so new and it was a month and a half into the new year. And so a lot of employers may not even be aware of this restriction, but there are monetary penalties associated with it. So if you believe you may have issued over the past couple years restrictive covenants for employees to sign, then you're going to want to consult with your legal counsel ASAP, because you may need to get a written notice out to those employees, notifying them that those provisions are no longer enforceable. Now, specifically, who is bound to comply with this written update notice? It's employers with any connection to California, a California presence, or California employees. So any of those circumstances, an employer should be prepared to comply with this written notice requirement. And employers that specifically are bound to it would be, for example, employers with a California presence that they must notify employees who are California residents, employers with California presence, but who are not California residents, and employers with no California presence, they still must notify employees who are residents of California. So again, it gets a little complicated. Consult with your counsel for any questions if you think potentially you may have issued some restrictive covenants. And lastly, and probably most concerning for employers, is the updates in the law have now provided affected employees with a private right of action against the employer that included prohibited provisions in the agreements, or who are seeking to enforce these non-enforceable provisions, or who are continuing to maintain these provisions without providing the required written notice that we just discussed. So a violation constitutes an act of unfair competition under these new updates to the California Business and Profession Code. And so a current or former employee who is subject to any unlawful provision is able to now bring a claim for injunctive relief, for damages, and reasonable attorney's fees and costs. So again, this can be very costly for the employer, and it should, because now that there is a private right of action that employees can bring, an employer's risk benefit analysis regarding these covenants should be impacted. And the risk now is not simply that these covenants won't be unenforceable, it's that the company with the unlawful covenants will face claims potentially from affected current or former employees. And they may also be able to now get, or will be able to get if they prevail, attorney's fees and costs, amongst other remedies. So again, be very cautious with any restrictive covenants going forward. And of course, I did mention that there are some exceptions briefly, just so you're aware. The new laws still preserve the existing exemptions to California's non-compete restrictive covenant laws. And those include, for example, provisions for partners in a partnership and members of a company, as well as restrictive provisions in connection with the sale of a business. And if you have any questions about that, please feel free to reach out to us. We assist companies all the time in those type of situations. But again, in general, make sure that you're reviewing your company employment agreements and double check to see if you have any restrictive covenants there. And if you do, consult with your counsel. Okay, that was a lot. So please, if you have any questions about that, feel free to reach out in the Q&A. Next slide, please. All right, I'm going to shift gears here, and I'm going to quickly go over workplace violence prevention plans. Last September, the legislation went into effect that requires virtually every California now to implement a comprehensive workplace violence prevention plan with the very specific requirements. For the sake of time, I'm just going to be hitting the highlights of what is required here. So if you have any questions, please don't hesitate to ask at the end of our presentation. The new law adds a section to the California Labor Code, and it will be implemented by Cal OSHA. As I just stated, this update requires that employers make an effective plan that is aimed at preventing workplace violence, and it must go into place by July 1st of this year. So the plan must go into place as of July 1, 2024. The plan may be incorporated into an existing injury, illness, and prevention plan, or it can be a standalone plan, which we recommend because this is such a new change in the law. There could be other updates or revisions required down the road. So we recommend that you have your workplace violence prevention plan as a standalone separate policy that can be updated as needed and not make it part of the handbook. So every time, for example, you have to make a revision, you have to update the whole handbook. It just makes it easier, but either way is okay. Now, I will go a little deeper into what's required in the workplace violence prevention plans, but I did want to also mention that in September last year, there was another Senate bill that was passed, and it expands California's the employer's ability to protect their employees in the workplace. And it has to do with seeking restraining orders. So currently, California law enables an employer to seek a temporary restraining order to protect employees from a person who has engaged in actual violence or has made a credible threat of violence. So in that situation, an employer may file for a temporary restraining order to protect the employee and their immediate family members. So, for example, if a disgruntled employee sends a text message threatening to attack an employee, in that situation, under current law, the employer may seek a court order to keep that threatening individual away from the workplace, etc. So while there is some protections already existing for employers to seek that type of protection for their employees, it does have a limited scope of the misconduct that is related. It has to be actual violence or a credible threat of violence. But with the new law, it's actually expanding that. So the law is going to include not only the actual violence and threats of violence, but also harassment. So under the new law, harassment is a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person and serves no legitimate purpose. The course of conduct must be that which would cause a reasonable person, so there is a reasonable person standard, it would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress. So, for example, under the new law, if a ex-boyfriend of an employee was coming around and just every day, like harassing asking them, their former girlfriend, for example, to get back together, or just standing there and looking at them in a threatening way. There's no actual violence there. There's no threat of violence per se, but that would constitute under this new definition harassment. And under the new law, employers would still be able to get a restraining order. So again, that really gives a lot more ability for the employer to protect their employees because harassment is broadly defined. However, this update to get restraining orders on behalf of employees even though legislation was passed last year, it doesn't go into effect until January 1 of 2025. But because it will impact workplace violence prevention safety plans, I did want to mention that to employers just so they're aware that there is going to be an expansion of their ability to get temporary restraining orders on behalf of their employees. So with that, I will go back to talking about the workplace violence prevention plans and who is covered. So the requirement for these plans applies to all employers and employees in the state of California, with a few limited exceptions. The plan does not apply to workers who are teleworking from a location of the employee's choice or employers that are already regulated by existing standards for the healthcare industry. Also, the plan does not apply to work sites with less than 10 employees, and not just less than 10 employees. It's if the work site has less than 10 employees present at any given time and not accessible to the public, and the employer complies with the injury and illness prevention CalOSHA regulations, then the worksite may be exempt from the new law. Now, presumably, all employers have been for years complying with injury and illness prevention regulations set forth by CalOSHA. So, assuming your organization is doing that, and it speaks to that in your company handbook, If you have less than 10 employees present at any given time and your worksite is not accessible to the general public, you also will be exempted from having this written workplace violence prevention plan in place by July 1st. So if you think you may be exempt, reach out to counsel to confirm that that is the case, and you don't have to go through with this, because it is quite onerous on the employer to put this new plan into place. Now, what is the definition of workplace violence? Workplace violence is defined broadly as any act of violence or threat of violence that occurs in the place of employment, and it would include verbal and written threats, certainly incidents involving the use of any firearms or dangerous weapons, and that's regardless of whether an employee sustains an injury. And also, the definition captures um, acts that some may think waters down the meaning of actual workplace violence. And it includes a threat against the employee that results in a high likelihood of resulting in psychological trauma, stress, regardless of whether the employee sustains an injury. So in this instance, there is no reasonable person test. It's the definition is subjective. So even a seemingly innocuous comment to an employee might be considered workplace violence based on the perception of the employee. So that's very important for the employer to recognize that if an employee is feeling threatened in any way under this workplace violence prevention plan requirement, action will need to be taken by the employer to make sure that the issue is addressed. Now, enforcement again begins July 1, 2024. So if you haven't started working on getting your workplace violence prevention plan in place, I highly recommend you get going on it, because it will need to be distributed and ready to go as of July 1. It's quite comprehensive what needs to be included, so I won't go over every item, but in general, the plans must be in writing. They must be easily accessible to the employees. You definitely included will need to be methods that the employer will use to implement the plan, procedures for how the employer will accept and respond to reports of workplace violence, procedures regarding how employees are to communicate any issues that come up, evacuation sheltering plans, procedures for recognizing and identifying workplace hazards, and procedures for investigating and correcting any incidences. In addition to having this written plan, employers must also maintain a log of all workplace incidents. And the log, again, has to be very comprehensive, and you want to be very detailed, but it should include date, time, location of the incident, the type of violence. So whether it was verbal, what specifically was said, or if it was more physical nature. So be as detailed as you can. And also, what was the outcome? How did the company respond? What was done to protect the employee or employees who were subjected to the workplace violence, and what actions are being taken to prevent it from happening again? And so in addition to the workplace violence plan and the incident log, the employer is also required to train their employees about the workplace violence prevention plan. And all of this should be accomplished by July 1 of 2024. So it's quite a burden that is placed on employers now to get this going, and there's not a lot of time to do it. So if you need assistance with it, we encourage you to reach out to your legal counsel if you need any support in getting that together, because it is very specific what needs to be maintained in the plan. And lastly, employers must ensure that they are maintaining the records for at least a 5-year period. And records would include the incident log, the investigations, if that occurred stemming from any reported incident of violence, records of the workplace violence hazards that were identified, evaluations, corrections, and all of that must be maintained by the employer for 5 years. Next slide, please. Okay, so we've covered the notice requirements relating to the non-competes that employers have to do. We've covered the workplace violence prevention plans that are going to have to be in place, including training to all employees by the 1st of July of this year. And lastly, I'm going to quickly touch on an expansion to the Fair Employment and Housing Act. And that's relating to off-duty cannabis use. It's California, so this is not shocking that this has happened at this point. Effective the 1st of this year, the Fair Employment and Housing Act was amended, and employers are now prohibited from taking any adverse employment actions against their employees based on employees' off-duty marijuana use. So what does that mean? It means that it'll be unlawful for the employer to discriminate against employees or prospective employees based upon any required drug screenings. So employers would not be able to use the results of a hair or urine test for marijuana, for example, which detects traces of cannabis. They can detect traces of cannabis for days or weeks, and they could not use that in their decision to hire, fire, or penalize the employee. Employers are still able to test employees and potential employees for THC, the major psychoactive ingredient in cannabis that can indicate impairment. So that's still permitted. However, with this update, the law stops employers from discriminating against these employees if they test positive for non-psychoactive cannabis metabolites or metabolized THC that can be found in hair, blood, urine, or other bodily fluids, as these non-psychoactive metabolites do not indicate impairment, and only that the individual consumed cannabis in the last few weeks, presumably not while at work. Now, employers also are prohibited, besides just using any results from tests, employers are prohibited from requesting information from employees or job applicants relating to any of their prior use of cannabis, or using any information that the employer may have obtained regarding a person's criminal history related to cannabis. So again, as long as the employers are not using any of this information to make employment related decisions pertaining to the employee, then the employer will be in compliance with the law. Next slide, please. Now, what this doesn't do, this expansion of the cannabis protection for employees, it does not permit an employee to possess, be impaired by, or use cannabis on the job. Employers are absolutely still required to and are able to maintain, safe, drug and alcohol free work sites. So the expansion of FEHA does not impact that in any way. And really the purpose of this new law is to protect workers in California who use cannabis off the clock. So again, it's as far as workplace, if someone were to bring it onto the work site, that's not permitted. They certainly can't go off on a break and come back impaired under the influence of cannabis. That's not permitted. So with that, I covered a lot here. We can always count on California every year to give us a lot of new rules and regulations to apply. But I will go ahead and now pass to my colleague, Deanna Maxfield. Thank you so much.
Thank you, Lindsay, and thank you to everyone for joining us on this Leap Day afternoon. I'm going to talk about some new and new-ish laws regarding pay and leave time for employees. We're going to start with annual pay data reporting. This is not entirely new, but the deadline is coming up on May 8th, 2024. So this is your reminder, if you are subject to these requirements, to get started. It can take a while to gather all the information needed to complete a pay data report. And for those of you who aren't familiar with these, pay data reporting is required by the California Civil Rights Department, formerly known as the Department of Fair Employment and Housing. It collects data about employees' job positions, pay, race and ethnicity, and gender. The individual reports are not shared with the public, so someone can't go onto the CRD website and look up your organization and look at your report. But the idea is to gather aggregate data about pay equity in California and also remind employers that this is something that they should be thinking about. I'm not going to be able to get into all of the details of the report here. We could do a full hour on it, similar to the workplace violence prevention plan. But it's important to determine if this is something that you need to do. There are two types of reports: payroll employee report and the labor contractor employee report. A payroll employee report is required for private employers who had 100 or more payroll employees in 2023, with at least one of those employees being in California. A labor contractor employee report is required for private employers with 100 or more labor contractor employees in 2023, with at least one in California. Now, these are terms that the Civil Rights Department uses. A payroll employee is pretty straightforward. These are people that are on the employer's payroll directly. When they get their paycheck, the employer's name is on the paycheck. Labor contractor employees are on a third-party company's payroll rather than being paid directly by the employer. So an example of this, I had a client who is in the business of putting on events. They hire people for individual events on an ad hoc basis through a third-party company. The third-party company handles all the payroll for the workers. So those would be labor contractor employees rather than payroll employees. How difficult it is to complete this report is going to vary a lot depending on the size and nature of the business. If you only have long-term payroll employees, it may be pretty straightforward. If you have a lot of short-term employees coming in and out, that may make it more complicated. For example, going back to this client, they had a lot of these very short-term employees that they didn't even communicate with a lot directly. It makes it harder to gather that information. And it may not be apparent until you get started on the report how complex it's going to be. So the takeaway here is make sure that you determine as soon as possible whether you're required to file a pay data report. And then if you are, get started right away. The online portal is already open as of some time ago, so the reports can be submitted anytime. Next slide, please. Next, I'm going to talk about the expansion of California's paid sick leave requirement. This is probably something you're generally familiar with. There's been a requirement for paid sick leave for some time now, but starting this year, this went into effect January 1st, California requires employers to provide 5 days of paid sick leave per year. The former requirement was 3 days per year. You can choose to provide this leave in a couple of ways, either accrual or upfront. Accrual means that the employee earns paid sick time as they work. If that's how you choose to do it, they need to accrue 1 hour of paid sick time per 30 hours worked. You can also choose to provide each employee with an allotment of 40 hours of paid sick time at the beginning of each year of employment. You can also do that upfront allotment at the beginning of each calendar year. But if you do that, you just need to make sure that you prorate for employees who start partway through the year. So if someone starts in July, you can't wait until January to give them their allotment of leave time. You need to make sure that they're still getting the leave time they're required to have. I know a lot of employers also use a combined PTO system that combines sick time and vacation time. That's fine under this law. You just have to make sure that employees are still receiving enough sick time so that it's compliant with the law. There may also be local laws that could have even stricter requirements than the state law. I happen to know, for example, that Oakland has its own paid sick leave law. That's something that you're going to want to watch out for as well. Once an employee has their paid leave, they must be allowed to use it for diagnosis or treatment of a medical condition of themselves or a family member. So if you have an employee with a sick child and they need time off to take care of their sick child, that would be a use for this paid sick leave. If they need to go to the doctor themselves, that would be another use for this paid sick leave. The law also has a provision in it allowing victims of domestic violence, sexual assault, or stalking to use paid sick leave for medical or psychological treatment, which would probably be covered anyway, as well as other services related to the stalking or abuse, or to go to court. So if an employee needs to go get a restraining order and they have to appear in court for that, they could use this paid sick time for that. Of course, because it is protected leave, employers are prohibited from retaliating against an employee for using their paid sick leave. Something that's interesting about this law, and something that is a little counterintuitive, is that there's no provision in the law to ask an employee why they need the leave. The employee is supposed to just be able to use their leave upon an oral or written request to the employer. Unlike, for example, the California Family Rights Act, which has specific processes for a doctor to certify that the employee actually needs the leave, here they're just supposed to be able to use it when they ask for it. Hopefully, because it's only 5 days a year, that doesn't cause a huge problem. But if you have questions, of course, consult counsel. So the takeaway here is that if you haven't already, make sure to double check your sick leave policy to make sure that you're in compliance with this updated law that went into effect at the beginning of the year. Next slide, please. This is another new law that went into effect January 1st. Employees are now entitled to 5 days of bereavement leave for reproductive loss events. The law identifies miscarriage, failed adoption, failed surrogacy, stillbirth, and unsuccessful assisted reproduction as examples of reproductive loss events. Unlike the paid sick leave law, this leave does not need to be paid. But if an employee has paid vacation or sick time in their bank and they want to use that to make this a paid absence, they are entitled to do that. Similar to the paid sick leave law we just discussed, there's no provision in this law for asking for documentation. Even though this is somewhat modeled on the existing bereavement leave law, which covers bereavement leave for the loss of a family member, the new reproductive loss leave law is different in that it does not have a provision for asking for documentation. So the other type of bereavement leave, you could ask for an obituary or some other documentation of the loss. Here, there's nothing in there about that. So you're going to want to let your employees use the leave. Now, an employee may share information with you, and any information that the employee shares with the employer needs to be kept confidential. Obviously, sometimes that's going to include health information, which should be kept confidential anyway, but the law does have a specific provision that all information provided in this context should remain confidential. So the takeaway here is if you have written leave policies, again, review them, update them if necessary. And of course, any HR or management personnel should be aware that this is a new protected reason for leave for employees. Next slide, please. This is something that probably a lot of people are already aware of, but just as a reminder, California's minimum wage is now $16 per hour, up from $15.50 at the end of last year. The new minimum wage went into effect January 1st. Something that is easy to miss is that this also increases the minimum salary for exempt employees. So to be exempt from overtime rules, an employee must meet the job duties test, which you may have heard of. They need to do a job that fits into one of the categories that's exempt from overtime. But in addition, they must also be paid at least twice a salary that's equivalent to at least twice the minimum wage, the state minimum wage specifically. So the minimum salary for an exempt employee is now $66,560 per year. It's also important to remember that the California minimum wage is a statewide floor. Again, cities and counties can have higher or more stringent minimum wage requirements. For example, Los Angeles already has its own minimum wage, but that minimum wage is increasing on July 1st. There are different minimum wages for Los Angeles City and unincorporated LA County. So again, this is something that you're just going to want to check for your own locality to make sure that you're in compliance. And again, the takeaway here is this is a good time to check. Check that all of your employees are being paid at least the minimum wage. Make sure your exempt employees are being paid at least the minimum salary. Next slide, please. And finally, since we are talking about compensation, I just want to briefly mention that there is an updated version of the wage theft notice form, which is provided by the Department of Industrial Relations. This form may look somewhat familiar. You may have used this before, but the new version includes some additional notices about sick leave, the paid sick leave law we just discussed, and emergency or disaster declarations in the area where the employer is located. You don't need to go and send this form to all of your existing employees who've already received an earlier version of the form. You just need to use the new form next time it's required, which, as it says here on the slide, is on hire or 7 days after a change to an employee's compensation. So just next time you have to hand this notice out, make sure that you have downloaded the newest version from the Department of Industrial Relations website. And that is all of my content. So I am now going to turn it back over to Angela.
Thank you, Deanna, so much. And thank you, Lindsay. And thank you all. We have some questions, so I'll take them in order and I'll send them to the appropriate attorney to answer. The first question is, what if I don't have a workplace violence prevention plan in place by the deadline? And I'm going to send that to Lindsay to answer.
Thank you, Angela. Good question. Now, again, this is a new regulation, so I am not sure how strict or lenient Cal OSHA is going to be about enforcing it. I presume they will want to set a precedent that they will be enforcing it, so I wouldn't risk it. I would make sure I have, at a minimum, the written workplace violence prevention plan in place, like in writing, issued to all my employees, and I've at least had one, like a training session with all the employees, just going over the workplace violence prevention plan. But if you don't, I know Cal OSHA will be enforcing it at some point through their standard inspection, citation, and penalty framework, as they do with other violations. So depending on the nature of the alleged violation, specific to workplace violence prevention plans, penalties can climb as high as $25,000 for a serious violation, or over $150,000 for violations that are classified as willful. So it'll be interesting to see. Probably at some point next year, we'll have a better idea of what is going to be deemed willful versus a serious violation, and how Cal OSHA has sought to enforce this new law. But it will also require any employers who are ultimately deemed out of compliance to abate alleged violations to Cal OSHA's satisfaction. and that potentially could include changes to the employer's particular policies and procedures. So again, it could be quite costly for the employer to not comply. So my my best advice to you is make sure you comply timely. You still have a decent amount of time. You don't need to have it ready to go until July 1st.
Okay, thank you. Next question, can I discipline an employee if I find out the employee has marijuana on their person at work, even if they are not using it in the workplace? And Lindsay, I'll have you answer that one too. It falls under your purview.
Yes, yes. Again, now I say this with a caveat because it is California, and there are employees most certainly who are probably using cannabis for a medical reason. So I would be cautious before disciplining any employee, especially if you know they have some type of medical condition or disability. So you'd want to consult with counsel, but in general, employers are permitted absolutely to maintain a safe workplace and absolutely a drug-free and alcohol-free workplace. So that would be appropriate to keep in a policy that, you do not permit, drugs or alcohol on the workplace. Now, of course, there could be exceptions if something is medical for, medicinal use. However, an employee still cannot be impaired while they're at work, particularly depending on what the employee is doing. So again, yes, you can prohibit employees from bringing drugs and alcohol, including cannabis, into the workplace, even with this expansion to the Fair Employment and Housing Act. But you're going to want to be cautious on how you address it and do it on a case-by-case basis, because some employees may have some type of a medical condition. So you just want to be careful with how you address it.
Okay, yes, absolutely. And all the more reason to have an updated handbook so you make sure you cover that. Okay, here's one. Can I ask an employee to find someone to take their shift? So I'm going to ask you to answer this if you could, Deanna.
Yes, I'm guessing this is probably about the paid sick leave. No, you can't. There is actually a provision in the law that says no, it can be an attractive idea, right? You need to find coverage for when you're going to be out, but the paid sick leave law says that that's not something that you can require of the employee.
Okay, thank you. Here's another one. Does the 5 days of sick time also apply to part-time employees? And if so, if someone normally works 20 hours a week, will it be 20 hours per year?
That's a good question. So this isn't quite your question, but I'll start with, yes, the law applies to part-time employees. It applies to all employees. If an employee is part-time, you can for all employees, you can satisfy the requirements of the law by either giving them an allotment of 40 hours at the beginning of the year, and that part of the law does not distinguish between full-time and part-time employees. But if you use the accrual method, you're compliant if you let the employee accrue 1 hour of leave per 30 hours of work. So you might, if you have a lot of part-time employees, you might want to use the accrual method so that they're accruing as they work. And obviously they're not working 40 hours a week, so they're going to accrue more slowly. But that's okay as long as you're meeting that accrual rate that's required. So that may impact your decision of what type of paid sick leave policy you want to have.
Okay. We get some form of this question a lot.
Yeah.
Especially when we're redoing handbooks, because it can get what seemingly should be very straightforward gets very complicated. Especially some companies have people get more days off per year upon anniversary dates. So that becomes even more tricky when you're trying to calculate it. So it does help to consult someone. Okay, let's see. Do local laws that have higher minimum wages mean that the salary requirement for exempt employees is higher in those areas too? So I'm going to ask you to answer that as well, Deanna.
Sure. Generally, no. So the statewide law that says this is the minimum salary for an exempt employee specifically says that it needs to be twice the state minimum wage. However, a local government could specify their own minimum salary for exempt employees. Most of them don't. Most of them just have a different hourly minimum wage, in which case you can use the state minimum wage to calculate the exempt employee salary. So I'm not aware of any particular local law that does have a higher minimum wage for exempt employees, but it's possible. So you will want to check your local laws either way.
Okay. Do we have time for one more? This looks a little, let's see. This one, some of these look a little bit specific. Let me ask this one and then I will email the last two directly. How are employers supposed to know an employee's race or ethnicity? And I'll give that one to you, Deanna.
Sure, I think this must be about the pay data reporting. The California Civil Rights Department says that their preferred method is by self-identification, so by asking the employee. That can obviously be a little bit awkward. The Civil Rights Department does actually have some proposed language that you can use to send to employees to ask them to identify their own gender and race or ethnicity. So that helps smooth things over a little bit. If an employee refuses to self-identify, then you can use what they call observer identification, which is basically when you look at the person, what do you think? But that's obviously not the preference. You're supposed to make good faith efforts to talk to the person and see how they identify themselves.
We've had this come up too.
Yeah,
When we
yeah,
were doing reporting for a company that
yeah.
was rather large, so it got a little bit tricky. Well, listen, we are at the 1 o'clock hour. I want to thank our presenters from our firm. I want to thank all of you for attending. We appreciate you logging in and learning about these. We have periodic webinars about different topics. The next one will be a business law webinar, which is very helpful if you want to just take basic precautions to try to avoid a lawsuit or claim. And we'll be sending out information about that one fairly soon. But thank you again for joining us. We appreciate your time and have a wonderful rest of the weekend. Take care.